Hello, good morning. Sounds like it's working, huh? I can hear myself. All right. So thanks for coming. Do we have any new attendees? I know we had a few people sign up. You're new? Okay. Great, thank you. You're new, but you know me already, right? Okay. Well, welcome to our newbies here. So for those that don't know me, I am StephanieParson. I'm a full-time real estate broker. I'm here today with one of my teammates, Sharon Brummer, and a colleague, Dominic in the back, who's here to help out.
Hi, everybody.
So we have over 50 years combined real estate experience. So that is our true bread and butter. We specialize in working with seniors. We also provide downsizing assistance for those needing extra help with the move. So if you have questions on that, need further information, please, we're always available to talk or set an appointment with you. So we do a different topic every month. This topic today that we're at is avoiding the probate pot, okay? And that was something that this lovely lady over here, I don't know if you termed that or that's something, pot. It worked for me. I'm like, that's a good way of saying it. So anyway, real quick, a couple housekeeping things. We will run from about 10 to 11 and then have questions and or if we get done completed with Monique's information before that. And then we will have another person coming in and he will be here closer to 11 and he's gonna, kind of lead a discussion and talk about the big beautiful bill changes that affect seniors. So looking forward to that as well. So if you can please hold your questions to the end. You do have handouts to jot any comments, questions, so you don't forget them. And there's also some nice little handout worksheets there for you, to follow through on any of these estate planning things that you'd like. So, all right. So, without further ado, Miss Monique, you want to come on up? Thanks so much for being here today. And I'm going to have you sit over there. Oh. Come up, you want to use the step? You got really high heels on. I can't do that even without high heels. Make you hop up here. Oh. All right, so Monique, tell us a little bit about yourself and your business and why you're here.
All right. Well, good morning. Good morning?
Yep.
That's better. All right, so I am Monique Hannum, and I am from the lovely island of Jamaica. Yes. And I started law in the Caribbean. I worked for the Attorney General's Chambers, did an LLB, which is kind of Bachelor of Laws right after high school. And then, like most stories go, I ended up in the United States because I fell in love with a Navy guy. So now we live in Wentzville with our 3 boys, and I've opened my firm about 3 years ago in Wentzville, where we do mostly estate planning and probate, some litigation, but mostly estate planning, your wills, your trust, powers of attorney, that kind of thing, special needs. I absolutely love practicing law. I love it. This is my jam. And when it comes to probate, I could go all day. We're not going to go all day, though. Right, Stephanie? We're not going to do that.
No, we can't. I'm sure you have things you need to get to after this, too. But yeah, I'm sure we have Monique's information on the handout. And she will be leaving some information here that you can pick up afterwards. But I'm sure, you welcome phone calls and questions. So thank you so much for being here today. And you have 3 boys. How old are they?
14, 13, 10.
Oh my goodness. All right.
Never a dull moment.
Well, you're an amazing mom. 3 young boys and a thriving business. So and you're giving up some time today too. So thank you so much.
Thank you for having me.
All right, well, we're going to dive in here and get started and talk about some probate pot thing and estates. So, so first let's talk about what is an estate and an estate plan.
Okay. So think of your estate as everything you've got, okay? And your estate plan is you making a plan as to how you want those assets transferred and to whom you want them transferred. I think the third bullet point I definitely want you to pay attention to, because a lot of times we think of estate planning as just planning for what happens after we die. But we really need to be also planning for incapacity, right? We're living longer. And so many times we're going to deal with dementia, Alzheimer's, or just different things that reduce your capacity. And so we want to make sure we're planning for that as well. So that's what your estate plan is, simply put. Okay.
Great. All right. So tell us, you said about a disability. So that could be, a mental decline,
Right.
Inability to communicate, or maybe
Yes.
even a physical.
Or sometimes physical as well. You can't, get yourself to the bank or get yourself around to do business, and so you need someone named to act for you, right? So we have our powers of attorney and so on.
Okay.
So that's what estate planning is. Just make sure you shore up your plan with both planning for not just after you die, but what happens if something were to happen to you and you can't take care of things the way you used to.
Okay, all right. So I know in the handouts we had some little exercises with this WWWH. So that's an acronym that I guess you have to answer all these questions, run through your mind about all these things. So explain that to us. If you don't
It's
mind.
a horrible acronym, but you get the idea. It's like when you were studying, adverbs or something in school. So you want for each thing you have, sit down with some tea or wine or whatever it is you drink. Think of all the things you have. What do I have? Think, where is it located? Is it at this bank over here? Is it with my broker? Is it in Arkansas? Or, in another state? Where is it? And then, who do I want to get this if something were to happen to me? And then you also have to ask yourself, well, when do I want that to happen? Do I want to gift it now? Do I want to gift it, after I've passed away? And then the how is also going to be important. How do I want to do this? Will I be doing a deed to transfer the property to my son or my daughter? Or am I going to go to the DMV and do a TOD on my car and say, this is who I want to have it when I pass? So we have to figure out the what, where, who, when, and how. And if you've done that for everything, you're in a pretty good place.
Okay, so what happens if you don't take care of all this, either through these other avenues that you kind of quickly mentioned, or that you truly have a full estate plan and will and everything? What happens if you don't?
Yeah, it's a very good question. So we call that being intestate, right? So we have, if we don't make a plan and we don't say what happens to our property when we pass, the state has a default, right? The laws of intestacy will step in. And this applies if you don't make a will to say who gets what, or if your will is invalid for some reason. So, occasionally we see wills coming from out of state, or maybe they were done online and they weren't properly witnessed. And so we're not able to rely on those wills. The state is going to say what happens to your property in that case. The other potential for this is if you do have a will and it was not sent to probate within 1 year of death. If that's not done, that will is going to be invalid, void. The courts will not rely on it, and that's a very bad place to be. So we want to make a plan, but we also need to be telling our family members, if I've made a will, you need to get it before the probate court within 1 year of death. And I'm going to, there's several instances where I've seen that not done. But I had a client at one point who stood to inherit. It was a mobile home park. It was doing pretty well too, and it was to be his under the will, but the will was never brought to probate within 1 year. And so about 5 years later, let's just say he was sharing that property with about 9 other persons because the default rules of the state kicked in, right? Because we couldn't use that will. And so I think in the end he ended up with 1/8 or something, like pretty small fraction of what was supposed to be his entirely, right? So just bear that in mind. Within 1 year of death, that will needs to be probated, okay?
And I know some of you are making faces like, what in the world? But we come across this fairly frequently. I mean, I know that that's your business, but we come across it in real estate transactions.
Yes.
Quite frequently. And so this is a very important thing, that we deal with as well, is trying to tell people to be proactive and get this taken care of in advance, because it becomes a problem if you don't. So, all right. So, how many of you want the state getting involved and saying what's going to happen with all your worldly possessions and everything? Anybody? No? Okay. All right. Just asking. Just thought maybe. All right. Well, I'm sure there's more ins and outs of that, but that's the basic of that. So,
that's the basic.
All right. So we don't want that. All right. So let's talk a little bit about this if it does go to the state. Okay.
Occasionally I've met people who are quite fine with the way the state would dole this out, right? So maybe that's you, but if we're dealing with intestacy and it's the state that's deciding, if you are married and so you've left a spouse, the spouse will get, if you have no children, 100%. If you have children, then the state is going to share your assets between your spouse and those children, okay? It gets a little bit tricky if you have children that are not with that spouse. Your spouse gets like $20,000 off the top, and then you start sharing a half to the spouse and a half between the children. But basically, just bear in mind, there will be sharing between the spouse and the children if you have a spouse and children. And so for those of us who, for one reason or the other, want to disinherit a child, you're going to need to do a will, right? Because the state is not going to remove that child from the equation for you, right?
So the state doesn't know what your personal choices are,
no.
what your wishes have been, and who you liked and loved and want to include or give more or exclude.
Yes.
So you have no say in the matter.
No. And again, I had a client whose daughter moved to live with mom, to take care of her, took care of her for several years. The idea was she was to inherit the house. Mom did not do a will in time. She passed away. And so there was a brother who had not been home for about 10 years, totally estranged, and he got a half, okay? So that's kind of what you're dealing with if you do not put something in place, right? Then, of course, your children or their descendants will share. The next slide kind of goes a little further. So, what if when you pass away, you didn't have any children, you weren't married? Well, then we go to your father, your mother, and they share with your sisters and brothers. So that's like the next line.
So what about like halves and steps and all that?
Not the steps, unless they were adopted. If they're adopted in, then it's a little bit different, right? And I will say this, if their children and paternity is questionable or wasn't established, then you want to take care of that. Add them to the will if you want them to inherit, okay? Yeah.
And that's the reason why I brought that up, is because with all the blended families we have today, and I mean, I have one of my children has, a child that they claim to be theirs, which isn't a blood relative, but he is to us.
To us, right.
So that's something we have him spelled out.
Yes.
But I mean, it can really get, if you leave it up to the state, they're not going to be acknowledged at all, right?
They're not. And persons you may not want to inherit will come and they will inherit. I believe at one point we had I think of it as a pie. I got pots, got pies. I'm always in the kitchen, but think of it as
We like food.
think of it as a pie. And we got to the point where we were doing math. It was like 1 out of 27th share that somebody was getting. That's how complicated it got for one of the estates, because there were many kids who died and left other kids, and so you end up with a huge tree and you're trying to do shares, and then you find out some of the one here is in prison in California or something like that. It just ties everything up and you're just stuck. So very good to do a will, make sure it gets probated within a year. Okay.
So what are the other father, mother, brother, sister? Yeah.
Well, if there's no one in those lines, then we go to grandparents, okay, and uncles and aunts. And then after that, we go to the great-grands. And then after that, eventually, if there's no one in your line, above or below you, it goes to the state, and the state gets it.
Back to that again.
Well, by that time, I don't know if we care, but there's nobody showing up by then. But.
Well, if you don't have family and you haven't done a will and an estate plan, and you don't want it to go to the state, that's what's going to happen.
Done.
So create one and leave it to an organization or church or
definitely.
Something like that.
Yeah, I had a client who it was he had a favorite bench he liked to sit in after work. Look out at the lake, and he said, whoever it is that's taking care of that bench, I want them to get my estate. so we did some digging. Wow. That's who he wanted to get it, but you get to do that. You get to do that.
Okay. All right, so now let's talk about, next slide here. We've got a slide called cons. So, what is the other cons that we haven't talked about when you're forced to go through probate?
Yeah. And I think let's kind of set up a little bit of a framework here, because we said we were trying to avoid the probate pot. That's how we started. But let's just say there are some scenarios that are bad and there's some that are worse. So think of it as your ranking. The worst possible thing you could do is no planning, no will, nothing, and the state decides. Okay, that's what we definitely don't want. Next in that rank would be, okay, I've got a plan. I made a will, right? I made a will and I say who should get what. There's still some cons to that. We're not doing the best we could because wills have to go through probate. Yeah, wills have to go through probate. And so for those of us who are centering our plan around a will, the con is it's going to have to go through probate, go through the courts. It's expensive. It's expensive. And I mentioned Stephanie.
Yes, and you know what? I failed to. I ran out of time. I meant to do that. Go on your website and actually do a calculation. But maybe you can give an idea off the top of your head.
So if you're trying to get, say, a $300,000 house through probate, you might be looking at about $7,000 in attorney's fees. Okay, and that's the floor. That's the lowest.
So that's the minimum.
That's the minimum that the attorney is going to get. And so if you imagine if you have, maybe a rental property and then you have your home, etc., you could be paying, or not you, but your family could be paying significant attorney's fees to get the properties through probate. So that's kind of one of the downsides of having the will as the main thing that you're relying on. It's also drawn out. If we could go back to the slide before that. And so, probate minimum is 7 months. A lot of times it goes longer than that by the time you're finished. It's also very public. Everything is out there for everybody to see, especially with CaseNet now. You can just go on your phone, log in, go and search and see, oh, Sherry left the house to so-and-so. You can see everything. And of course, then we also could have some other consequences like creditors coming. Probate is the time you publish in the paper and say, hey, so-and-so died, come file your claims.
Yeah, file your claim
file
if
your
you
claims.
think that this person owed you some money, right?
Yeah, come sue us, You got 6 months, but come sue us. That's what probate does. We have to publish those notices, and the claims come in, and people come out of the woodwork. So, your second level up where you're doing a will is kind of good, because the state isn't saying who gets what, but it's also not the best you could do, okay? Because we're still doing probate. Does that make sense?
Yeah.
Okay.
So getting back to the fees there, also, this is just what the attorneys, and correct me if I'm wrong, do you have to, should just ask the question, do you have to have an attorney if you are handling a relative's estate or somebody's estate? Doesn't have to be a relative. You have to have an attorney to take it through probate, is that correct?
Depends on the size of the estate.
Okay.
So in Missouri, we do have small estates. If you're under 15,000, you don't need an attorney. You can do that yourself, probably. There's just an affidavit that you would fill out and file it with the court. 40,000, above 40,000, we have a large estate. You will require an attorney. The court will not allow you to go through probate with assets over 40,000. Okay, because that's considered a large estate, and there are too many rules, and they don't want to deal with with a lay person trying to get through the courts.
I guess it's good to say it's not too hard to get to that 40,000 point.
It's not.
So, yeah, that's good.
And it's very avoidable, which we'll get to. So,
But I know you mentioned that if there's a executor or a personal representative, that they are also allowed to collect fees out of there, so it can be like double.
It could be double, right? So that same schedule there, starting at 2%, going up to 5%, that applies to both the attorney and the executor or personal representative, whatever you call it. So yeah, you could pay that twice, essentially. And the fees could be more. If it's more complicated and we have to be in court all the time arguing and doing motions and so forth, or sometimes there's a business we have to take over, get it through probate, then we might charge more.
Okay. So, and that is something that you do. People hire you.
Yes.
And that's what attorneys who do probate cases, that's what they do.
That's a part of it. Yeah.
Is this this fee schedule here? Is that's the minimum? Can everybody charge more than that?
That's the minimum.
Okay.
I've not seen executors charge more. That I haven't seen.
Okay.
But attorneys, we have charged more.
Okay.
And of course the court has to agree that it's reasonable that you get more based on what you've done. Okay.
Are they pretty good about?
Yes, I think so.
Okay. I'm just asking these questions, and then I assume as an executor, you have the right to say, no, I don't want to collect those. We're going to leave it in to distribute to, yeah. Okay.
Yes, there are clients who've done that, especially because it would be taxable, it's income, and so it might put them in another tax bracket.
Okay.
So generally I say talk to your accountant and see if they think it's a good idea, and if not, you can say I don't want it. I'll just take my share.
Yeah, okay, all right, okay. Okay, so, yeah, you want to, that's another con, is it's expensive.
Yes,
absolutely.
expensive.
So, all right, so we have a plan. So let's talk about this.
Okay. All right, so we've gone from you did absolutely nothing and the state decides and you go through probate to you did a will. We're still going through probate. It's kind of good, kind of not too good.
So I think that's a common misconception for a lot of people. Well, there's a will, but with a will, you still have to go through probate.
You still have to go through probate,
yeah.
yes.
Okay.
And so for my estate planning business, I try to make sure that there are several options that clients have, right? And so we're always trying to find a way to make a plan that takes care of everything but doesn't need probate. all right? So we might still do a will, but we will go through all of the assets. Remember, we started with the what. So we're going to go through our list of whats, and we're going to say, okay, is there a way I can pass this thing, this asset, to someone without probate? And we'll find a way to do that. So, it talks about have a plan. So we want to designate beneficiaries. We want to name beneficiaries on everything if we can, right? And so that's going to be transfer on debts, beneficiary deeds, gifts, trusts, right? So even if you have a will, you want to do those things because we're trying to avoid probate. If something goes through probate, it should be because we didn't get to it, and we don't want it to be much if that happens, but we want to avoid it. I think the next slides will go into pot. So that's a pot. That's my probate pot. Think of probate as a pot. Things outside the pot do not have to go through probate court, right? And that's going to save time, money, energy. You know what? It saves relationships sometimes too. Okay. So we are going to try to find a way to keep things out of that pot. And that's what the rest of the time will be kind of about.
Talking about the other ways that is you can take care of some of these, that list there. Because an estate plan, it sounds expensive, doing a will and an estate plan. So what's on average are we talking about costs for something like that?
It depends. Lawyer's favorite two words, but cost depends. Let's see. If you are thinking of doing what I call in my office a TOD plan, transfer on death plan, right? Where we're just trying to put beneficiaries on everything. So you're doing a will just in case. You're doing a beneficiary deed for your house, maybe a beneficiary bill of sale for your stuff, your powers of attorney, etc. Then that for a couple would run about $1,500. For a single person, you're probably about $800. For clients who want to do trust plans that are a little bit more involved, whether it's a revocable live-in trust or Medicaid asset protection trust and so on, you're about anywhere between $2,000 and $6,000. So it really depends on what it is that you are doing, okay? Now, I don't believe every client needs a trust. I don't think every client needs a trust. But I do think you need to have something in place and avoid probate if you can, okay?
What's the best way to determine what you need if you don't already have something in place, or, we need to coach our children on these things that they need to take care of?
I think there's a lot of information out there, and most estate planning firms or probate firms will give you a free consultation. Most of them will. So, you want to sit down with somebody and say, here's what I have. Here's my family. What do you think? How can we do this? And maybe see what the alternatives are. And, some people want a Cadillac. Some people want a Camry. But you kind of decide based on your needs and what your family is like.
So, I guess in my mind, I'm thinking maybe if I'm a younger person and I don't have a lot of assets yet, maybe some of these other avenues, and maybe just, having the will might suffice. But a lot of times as we get older, we have more of an estate, and we have more complexity in our family, and we want more control over what happens to our estate. So,
and especially with blended families, and if you have multiple generations, sometimes, and that's why some people use a trust, right? Because it's easier to spell out what happens, and you can have a bit more protection. For younger couples or persons, if they have children, I think they definitely need an estate plan. Definitely, if you have children, because I'll say to clients, how did you get here today? Well, we came in the car. I'll say, well, did both of you drive together? Yes. Just takes one accident, and no one knows who should be the guardian of your children. There's nothing set up for them, and so forth. So it doesn't really matter whether you're young or old. You need to have something in place. this is probably not the group that does a lot of this, but you can tell your kids, if you don't have a lot of stuff right now, you can do the will, and we can put a trust inside your will. So that trust doesn't exist as yet, but God forbid, if something happened to you, it would come into effect, and then you could say, who should take care of my children, and kind of set up, trust accounts and so on for them. But that's a very good question, but it does change as you get older.
Yeah. No, thank you for clarifying that. And it sounds like to me, you're talking about a lot of different options.
Many options.
That I know a lot of times people that I've talked to and I deal with, they go straight to, this full-on complete package.
Yeah.
So, which a lot of times is needed, but I like, the approach for maybe more of a budget-conscious scenario. So, okay, all right, so I know we might have gotten off track there. I'm sorry.
So when is probate necessary? Because you need to know what causes probate so you know how to avoid it, okay? So we need probate if the person dies and they have an asset and there's no named beneficiary, okay? Or it's titled only in their name. So right now, you're doing a little bit of planning probably. If you own your home with your spouse and you're owning as joint tenants, for example, you kind of have a little plan in place, because we know if one of you passes, the next one inherits the whole thing. And that doesn't need court, right? Because you're joint ownership. Some people already do that with bank accounts, but if we don't have that, joint ownership, and we don't have beneficiaries, we're probably going to be in probate. Okay? Does that make sense? So own it with somebody or put a beneficiary on it. That's how you get to avoid probate. And that's what that's talking about.
Okay. All right. So specifically a beneficiary deed we have here, that's something that will also keep that out of the probate pot. So tell us what you can use a beneficiary deed on, because everything can't be a beneficiary deed. I don't know, or can it?
Yeah, well, on your real property. Do you mind raising your hands if you've heard of beneficiary deeds, at least heard of it?
Yeah.
Okay. All right. So this is amazing. I love this. Missouri allows you to make a deed, say who you want to get your property after you pass, record that deed, and when you pass, automatically that person becomes owner. No probate needed, no court.
So, and that is what we, as Sharon's not here, we as realtors recommend. So when we talk to somebody, which we do talk a lot of times to people who are calling about, they have a parent that is declining in health, and we're going to look at who has ownership on it,
right?
And ask those questions, and if it's an urgent situation, you could quickly do a beneficiary deed,
yes,
just to keep control of that home.
Yes.
And so I know that's what we always recommend when we enter into a kind of an urgent, dire situation.
Right, and that's true too. If there's something urgent, the person still mentally knows what they're doing and knows about their property. This is a great way to avoid probate if you didn't get, the whole will, you didn't get things done that you wanted to. The beneficiary deed can do that. Now, the great thing about it too is it's still your property. You can do whatever you want while you're alive. You can sell it, you can, whatever. But if you still own it when you pass, then that person will be able to inherit. So, I'll have clients come in. Sometimes they don't know their parents did the beneficiary deed. So they come, they're like, oh my gosh, Miss Hannah, I'm gonna have to go through probate. I say, well, hold on a minute. Let us search the records and see if there's a beneficiary deed on this. And if there is, you don't have to worry about probate. Then all we're doing is just doing an affidavit to say, mom died or dad died. We file the affidavit, the records are changed and updated to you. So that's a very great way to kind of deal with what for a lot of us is our biggest asset, right? And not allowing that to go through probate. And you can leave it to multiple people. I just say don't have too many names. It gets really complicated. But,
Yeah, then you got the whole dispute over,
yes.
what to sell it for and what we need to do for it, and yeah, that we deal with that as well. So
it gets tricky.
yes, it does. All right, joint ownership.
Okay, so we talked a little about this. If you own the property jointly with someone else, and I say joint tenancy with rights of survivorship, those are the magic words that will allow whoever survives to get 100% of the property, then you're kind of in good shape. If you're a married couple, you bought the property together, you probably have that already, or tenants of the entirety. I will just say, if your deed says tenants in common, that means that share may go through probate, because we have to figure out who gets that share. Okay, so, but owning jointly and saying with rights of survivorship is going to allow whoever survives to just take everything automatically, no probate. So you might want to see a real estate lawyer, or when you go for your consult, with an estate planning attorney, bring your deeds so they can look at the deeds and see if there's a gap there somewhere, okay? Because it can get complicated, but yeah.
All right. Okay, so trusts.
Trusts.
The next, I guess, the highest level. That's how I think of it anyway.
I think of the trust as a Cadillac, and then there are different types of trusts too. So, but with the trust, this is great because you can put the property in your trust while you're alive. It's going to be managed by the trustees. That could be you, depending on the kind of trust. You're the one who benefits, and you can also say in the trust when you pass who the property should go to. There's also a lot of protection that you can build in. So if you're concerned about potential divorces for your kids later on, you might be leaving something to your son or daughter, but they're married, and you worry, if there's a divorce, will their spouse be able to take something out? Putting it in the trust and allowing it to run through to descendants, for example, will kind of put that aside and kind of protect it. And so the trust, I think, is probably the best way to go if you're able to do that. I'll say one more thing on trust. Occasionally I'll have clients come in and they would have done kind of the TOD, beneficiary deed type of approach. And then we start talking, and eventually you hear something like, well, so my son is disabled and he's getting XYZ benefits. And I'm like, oh, back up. What did you just say? Yeah, we don't want him inheriting because he might get kicked, lose his benefits. Right. And so you have to kind of have all of these conversations. In that case, we want to set up a special needs trust to get or inherit the property. Never leave it directly to that child. Okay, so it's things like,
there's a lot to consider.
There's a lot to consider. So go have a consult, and talk to somebody, and then let them figure out what's best for you.
Are we going to a disco here or something? Does anybody see these lights flashing up there? Does that mean something? I guess not. I don't hear any alarms going off, but so yes, that absolutely. And I know we have that very thing in our family. Right. And so there's special needs and things like, okay, we don't want this person to lose the benefits that they have, so this is the way we have to handle that. So a lot to consider. Yeah. This is something, transfer on deed. We did kind of, is there anything that, transfer on death. Anything that, those are things that we can
These are things that we can name a beneficiary on. So again, we're keeping things out of the probate pot, all right? We've done the trust, we've done the beneficiary deed. Now we're dealing with things like your cars, your trucks. Go to the DMV, tell them you want to make it TOD, transfer on death, to whoever it is. It keeps it out of probate. And you might not think about it, but every now and again we have clients that come in and it's like 2 cars that we're going to probate for. It's a headache. Like, no, just put TOD to whoever it is you want. There's no court involvement. It's cheap. You can change your mind, but it just avoids that hassle later on, okay? So TOD for your cars.
Okay. Bank accounts.
Yeah, same for your bank accounts. Go to your bank, check your paperwork, say, look, I want this to be, sometimes they call it POD, payable on death, right? Or transfer on death, right? So go through all your accounts. Say, okay, I want to name somebody. I want to name the person. Because if not, what happens is when the person passes, the kids go to the bank is like, we can't tell you anything. That's the first thing. They're not giving you any information. Like, we can't tell you anything. Sometimes we ask, can you at least tell us if it's over 40,000 so we know if we have a full probate? They don't really want to tell you anything. And then we're filing probate, and the money's tied up. It's literally just money sitting there, but for at least 6 months, nobody can touch it, you know? And so, if you put payable on death to whoever it is you want to have it, or you can own it jointly with somebody else, then we avoid that, okay?
Anything else on that side?
No, nothing
Okay.
on that.
All right. And then how about insurance and, your investment accounts or your 401k, your retirement accounts?
Yeah. Same concept. We're keeping them out of the probate pot because we're going to name beneficiaries. Now, name your beneficiaries. Go back and check though, because sometimes you did the paperwork when you had 2 kids and then later you had 3. Or maybe one of the persons that you have named is no longer in a good relationship with you and you don't want them to get it anymore. So you want to make sure you name beneficiaries and that you're distributing the whole pie, okay? We don't want 25% out there going rogue and nobody knows who should get that. So make sure you name your beneficiaries. Name contingent beneficiaries. That's important too, in case someone passes away or can't inherit.
Yeah. Okay. All right. In the pot.
Yeah.
So what could be in the pot, and what does that mean if we don't do these other things?
Right. So if in testacies, you didn't do a will or anything, so everything is going to go through court. That's what's going to happen. That's lowest level, did nothing. If you have a will, whatever you hadn't had a beneficiary on, that's going to go through court. Now your goal, remember, when you go home, your goal is to make sure there is absolutely nothing
Nothing in the pot.
that you don't have a beneficiary on or transfer on death on or joint ownership. So yeah, keep it out of the pot.
Okay.
All right, and we already did that.
Yeah. Sharing the
Back to
pie.
food.
Sharing the pie. We don't like sharing our pie. Not only with people we want to, not the state. Okay.
All right. So it's better to make a will, and I'm going to say not just a will, but it's better to have a plan, okay, and name beneficiaries. And the first check mark here, you're the boss, is very important. I cannot tell you how many times I have clients come in and they have different wishes from their kids. And it's as if, well, this is what I want. Well, I'm going to turn to you and I'm going to say, you're the boss. This is your stuff. This is your decision. And it is alarming how many times clients feel torn or guilty or, they're going to say this isn't fair or, does that make sense? But you're the boss. It's better for you to spell out what you want to happen. You work for this stuff. This is your life. So I tell clients, you're the boss, so you decide what you want to happen. Yeah.
So I think, can you give us an example of that maybe?
Things like that happen.
Yeah, the things that you don't want, what some would be a common restriction or directive that you may want to be able to put in there, that a trust allows you to do that. So
Yeah.
can you give an example?
Like restrictions and the wills to some extent. So you could write and say, I'm disinheriting this person. I intentionally make no provision for this person because they've not maintained a relationship with me. I had a client who said nothing to this person because he stole from me. So you can set those restrictions. Now you have a lot more control if you're doing a trust versus the will, right? But that would
So
take a
you
little
you can mandate maybe they have to be a certain age for them to actually get their
right
distribution or
yes,
yeah.
yes, and that's essentially creating a trust. But remember, I said we can do that in a will. If we don't want a trust right now, we can do the will and say in the will that we're creating this trust. We call it a testamentary trust, special kind. But yes, we use it a lot for people who have underage children. And it will say, for example, they do not get distributions until they're 25. Or, they get it for school or medical care, that kind of thing. But yeah, that's...
And what about when you have family members that, maybe have not, they're incarcerated or, they've had a history of substance abuse or something that they don't lead their life currently the way you think they'd make the best use of their inheritance if it happened today.
Yeah.
Can you?
Yes, and that's a very good question. I recently had a few of those, but given your child access to money is going to exacerbate whatever is there, right? So if they're good and with money and they're disciplined and they're diligent and so on, you're creating great opportunities, right? They can invest this, they'll do something good with it. If they're suffering with substance abuse issues or, they have a criminal history and they're not rehabilitated, then you don't want to hand them outright, $300,000, $500,000. Don't do that. And so that's when we will also create a trust. And so, you can, most times you're giving their share to another child and saying, you hold it for my son. You hold this for him. When he needs money, you give it to him. You can pay his rent, etc. Sometimes we put in there that if they, for example, can show that they've been clean for 6 months or a year, you kind of release it. But that's the thing with the trust is you just have so much control. You can be creative with it. And you can kind of set things out exactly how you want it, which is why people like it.
Yeah. So that's kind of unfortunately, the more people that you have in your family, the messier it gets, right? And unfortunately, there are a lot of times I've learned and heard of that those are common situations,
yes.
And it allows you to effectively deal with them and set that person up for, you're not going to set them up for failure and use it for bad things. You're setting them up for success.
Exactly.
So your legacy is directed the way you want it to. So.
And you give them an incentive to improve.
Yeah.
If you get better, if you get treatment, then here's your inheritance. So.
Okay. So any other comments about the slide, better to make a will?
I have here, many rules, so use an attorney. Just see an attorney. We've had wills that came in and it's not notarized with the what we call the self-proving affidavit. That means we have to commission witnesses. Most times those wills coming to us are 25 years old or so on. Nobody can find those people to come in and testify. And so there are all these little rules that we have to make sure we follow. So my main thing would be, if you're in Missouri, you're a Missouri resident, this is where your life is, go see a probate lawyer, estate planning lawyer, and work with them. Don't sit down and just download stuff off the internet and sign them, because 7 times out of 10 we can't use them. Yeah.
So how about the AI?
AI. You know what? I have a love-hate relationship with AI. I think it can be a very good tool, but you have to know what you're looking for, and you have to be able to see when it's wrong, which it has been. So no, go see a lawyer.
Thank you. I had somebody contact me about a real estate contract question who was a very new agent, and I answered the question, and there was I was challenged on it, and I said, well, I do this, I've been doing this for 20 years, and I take a lot of education classes, and I have to stay up on this with being the broker, and what I'm telling you is to the best of my ability correct. And the answer was, oh, I guess you know more about the contracts than AI.
No.
Yeah. I was like, okay.
Well.
I said, you please don't conduct your business by relying on AI to answer contract questions. So,
Don't
anyway.
do that.
All right. Do we go over everything on this?
We talked about that one. I think we can skip that one.
So we are almost done here. Round out the plan.
All right. So we've been talking a lot about what happens when you die. Morbid, very morbid. But don't forget, estate planning also is planning for incapacity, right? So make sure you're planning for that. So get your durable powers of attorney done, okay? Durable means even if you lose capacity, the powers will still be effective afterwards. And I'll tell you, it's not fun when, a child comes into the office and says, RMDs are coming up, my parent has these investments, they can't do the paperwork, I need a power of attorney. And I'm looking at mom or dad and I'm talking to them and they don't know where they are, they don't know who they're talking to. They don't know. And I have to say, I'm sorry, your mom, your dad cannot sign a power of attorney now. We're past that point. And once you get to that point, you're in court. We're doing a guardianship and conservatorship to get your child to be able to do what needs to be done. But yeah, if you've lost capacity, I can't let you sign a power of attorney. So the time to do those things is now, okay? And it might sound like it's not too horrible to be in court for guardianship or conservatorship. It is kinda. You have to ask permission to spend anything you need to spend. You have to do accounting and inventories every year, and they audit the accounts every year, and you're doing reports every year, all of which is avoidable if you had a durable power of attorney, okay? So that's why I say go ahead and do that. Make sure you do your healthcare ones as well. I recommend doing your living will. Some people call that advanced healthcare directives, DNRs, whatever you call it. But spell out what you want to happen, what kind of treatments you don't want if you're terminal, for example. Because it does take a burden off your family when they're not the ones deciding those issues.
Absolutely.
Yeah.
And that's where a lot of family issues come up, because mom would have wanted this. No, I think mom would have wanted
Right.
that. I think if you have it all written out,
write it all down.
Yeah.
Yep.
Okay.
And
What is this right
of sepulcher?
I don't know how to pronounce it.
I learned that way in the country, but it's naming someone in your power of attorney that would have the right over your body, your remains, your funeral. Most people never use this, but I did have one client who he had broken up with his wife like 15 years before, but they never got divorced, and we were trying to get his divorce done while he had terminal cancer. And he said, Miss Hannum, I know she's going to show up. I just know she's going to come when I die. And I said, really? And I think it was like Friday evening they called. They said he was going. And I went over there and we did the right to sepulcher in a power of attorney. He said, I want my sister to be in charge of my remains. I get to work Monday morning and my assistant is like, did you hear what happened at the funeral home? Because the not ex-wife, but the estranged wife from 15 years ago came, and she wanted the body. She wanted to be in charge of the funeral.
She showed up.
She showed up. And that kind of saved at least that client got what he wanted, but that's what that is. That can be put in your power of attorney if you think there will be some questions or disagreements about who should decide, what happens to you and to your body, okay?
There's a lot.
I know.
There's a lot. Okay. Living will, healthcare directive.
Well, we talked about that already, so I think that's good.
right.
That's the one where you say, it's called a living will, but it's kind of how I want to die.
Yeah.
You want to lay that out.
Yeah. Okay. Awesome. All right. Well, thank you for all that. I know it's a lot, and I know a lot of you have already have some of these things already in place, which is awesome.
Yes, good job.
But they need to be reviewed.
Yes.
And I think if you move to a different state, maybe
I'd get it reviewed.
Yeah.
I would get it reviewed if
Okay.
you went to another state. Yeah.
So how about questions? Who has a question yes, ma'am.
I'm kind of doing the beneficiary deeds and the TOBs and things like that. What about my personal property? It was listed there for named property. But, I mean, your like your collections and your furniture and
Yeah.
anything in your household, whether
So-
you're renting or you own the house.
Yeah, those are the things that you're saying they don't have a title.
Right.
So how do you dictate and those get dealt with?
You can start gifting some of them, right, and saying who you want to get them. I think
Yeah, no. I mean, do you start just listing your collections, make it kind of a will, or you just let it, whoever gets the house decide?
you can do the list and say who gets what in your list. I mean, in most cases, if that's all that's there, nobody goes to probate. They kind of just divvy it among themselves. In reality, that's what happens. But you could also have your will, and sometimes you'll do a list that goes with it that says, here are my pieces of property and here's who I want to get each thing. You can do that. Yeah.
Right.
Who is that person?
That's typically your executor or personal rep.
If you're just doing beneficiary deeds and TOBs, you're not going to have it in.
Yeah. It's going to be whoever has access to your stuff.
Okay.
I mean, in reality, that's what's going to happen. Whichever kid or so is there.
40,000.
Yeah.
You don't have to worry about
Right.
taking it to probate.
Mhm.
The only thing left, if it's not beneficiary or TOB or whatever, will be in the house.
Mm-hmm.
So
Yeah.
I can speak to that, maybe not in a legal manner, but if it's a property that you're renting, okay, then the landlord will deal with that, okay? Which there's a legal process for that, and a lot of times it means the stuff gets put out on the street,
it's
and then
abandoned.
it's a free-for-all.
Yeah.
Um,
Considered
for if it is a piece of real estate that's owned, then typically, if the family doesn't want to deal with it, then they turn to us as the realtors to have the resources and contacts to deal with it. So yes,
They
there's auction.
Sometimes they auction it, but
Okay,
But-
the realtor would take care of it.
Well, if you own the piece of property, okay, then that's going to have, if you don't have that, it's going to have to go through the probate process.
Well, I mean, the beneficiary.
The beneficiaries do,
Beneficiary
yes,
deed.
okay, so
Yeah.
They would be getting all this stuff in the house too.
they in real life, typically that does happen.
yeah.
It's not that it's the legal answer. It's just
So if I name
whoever's there.
deed, I just tell the beneficiary, make sure you give this to this and this and have a list for that person.
That's what I would do if I'm trying to avoid probate.
Yeah, and so that's why a lot of times that we would deal with the owner now who was the beneficiary on it, and they say, we got a house full of stuff and we don't know what to do with.
Most times they don't
so-
want to deal with it
Yeah.
either, truth be told.
Donna,
That's
that's okay, you're good.
My question is about probate, because you said all about real estate goes with probate. What kind of charges and fees that go into probate?
Okay, your phone? Sharon, do you know where Miss Monique's phone is? Is it? Okay, I'll get it. So we did have a slide on that, right? About the fees, what can be charged.
So there is a sliding scale of 2% to 5%, and there's a little bit of math involved. Thank you. Right. Okay, good. So, but if you go to my firm website, Hannum Law, we kind of have a tool there where you can put in the value of your estate, and it will calculate the potential probate fees. So, all right, give me a number that you would want to check. Like, how much is your house worth, for example? 200,000. Okay. So on a $200,000 house, the attorney's fees, the minimum, assuming that's sold in probate, is $6,050. Okay. So as the size of the estate gets bigger, the value gets bigger, we start taking smaller percentages, but that minimum is set by law. Okay. But that's what you're looking at on 200,000 house.
That comes off the top.
Yes.
That comes off
Mhm. Correct.
And you're throwing out a very low value number there. Ms. Donna.
Well, in St. Charles County.
So to quickly put that in perspective, you could, even at that valuation, I think a trust, if you wanted the Cadillac,
Yeah, it's still cheaper.
is going to be
It's still
cheaper than that.
Yeah,
Okay.
still cheaper.
Yeah. All right. Okay. Yes, ma'am.
If you have, you said, if you have a will, it needs to be submitted to probate within a year. If you have a trust, is that also true?
No, it's not. So remember, one of the main reasons why people do trust is to avoid probate. So the trust doesn't go through probate court. Ideally, it would never see court. Occasionally there are disputes and maybe that ends up in court, but no, your trust does not need to go through probate. Okay.
Ben.
Can you confirm this? So I'm the executor of my parents' estate, so first generation immigrant, so I'm dealing with parents that are older, don't even speak English. So my parents had set up a POA, financial POA, and when I had to deal with the Social Security, they're saying that the government does not recognize a POA. Is that true?
I'm not aware of that, no. Now, I know sometimes our powers of attorney will have special provisions inside them for dealing with Social Security, for example, so it could be.
It was a blanket statement, we do not recognize a POA.
Wow.
So we had to go through a separate process to do their version of a POA.
Okay, they want you to do their
Which is
form.
ridiculous because we can't get into the Social Security office. You know, a few years ago when it's all shut down, you got a language barrier, you got all kinds of things that we're trying to avoid actually happening.
I haven't heard of that happening, but
So,
number, give me a call.
Fred,
Yes.
do you have any any comment on that? And if
My name is Fred Dilbig,
Yeah.
I'm an attorney. I agree that I've never had that happen, but I know that, like when you're dealing with the IRS, they have a special power of
Special
attorney. You have to
power.
use a 2848. And if you're dealing with, I've never run into that with Social Security.
Not with Social Security.
Yeah, so I have no, maybe it was a bad day.
Who knows?
Yeah.
Tama?
That happened to me when my husband became pretty much incapacitated, I guess. I tried to deal with his Social Security, and they would not talk to me either as a spouse. They would not talk to me. She told me I had to go to court and be appointed by the courts as a guardian, but she could not discuss anything with me.
Yeah.
This was, your husband was still living then?
Yes, he's that.
Okay.
You might have the same person on the phone.
On the same bad day.
Hang up and call back and get a different answer.
I actually was in the office. I got to
Oh.
talk to a person in the office.
Okay.
But that's before they shut down again. So.
Right.
Yeah, I mean, we try to avoid the guardianships and conservatorships if we can, but sometimes that's the last resort is getting the court to set that up and put you in charge. So, yeah.
So I want to be respectful of your time because I know you had an appointment that you needed to get to. So, or if you need to go,
There.
yeah. Okay. All right.
Take
yeah.
one more.
One more question, and then we're going to kind of switch gears.
What are the steps I need to take to get the beneficiary deed for my house?
Okay, just make an appointment with an estate planning attorney or a real estate attorney. You can bring your deed with you. Pretty much that's it. If there's someone else on the deed that would need to sign, they will need to be there as well. The attorney will draft the deed, we'll get it recorded, has to be recorded before you pass, okay, or it doesn't work. And then we'll go from there, but it's pretty simple. And I don't know, I think the price is now maybe around $300 or so.
We did establish a trust, and we're advised to put the car title in the trust. So it says our names and then the name of the trust, right, on the car title, instead of this TOD thing. TOD would have been the same thing, yeah?
No, it wouldn't be the same. I think practitioners kind of differ on putting cars in the trust. Some people say put it in, some people say they don't recommend it. I typically don't put the cars in. But I think you're fine. If it's in the trust, it skips probate, which sounds like is your goal, right? So, yeah.
A thought on that is that if you have a loan on the car and you transfer it into your trust, that's an event of default, and the repo man will come in the middle of the night and take your car. So,
Right, no protection
yeah,
there,
that's not a good plan.
unlike your house.
All righty. Well, thank you so much. Can
Thank
we
you for
get
having
a round
me.
of applause for Monique? Thank you. You've been wonderful. Appreciate it. Okay. All right, Mr. Fred. I didn't see you for a long time sitting over there, and then all of a sudden, you did, yeah.
Well, oh, now I have a name. Good.
It is. Hi.
Am I supposed to?
Come on
I
up.
don't need these, but.
Well, just in case.
Yeah.
So,
Hi, y'all.
hey, so Fred Vilbig?
Yes.
Is that how you pronounce it? Okay. So Fred, tell us a little bit about yourself, and then, we're going to have a little conversation here.
So I'm an attorney in Chesterfield, been practicing for years, and
What was that? The microphone wasn't picking that
It
up.
must be a problem with the microphone. They can't come up with numbers that big. But I've been practicing for a long time. I do estate business planning. I do a lot of tax work, which is why I got introduced. I asked to do this. I'm the author of the Law Matters column in the Mid-Rivers News Magazine. I've been doing that for about, it's over 10 years now. I've got a book. I collected a bunch of columns into a book. And
You're meeting a famous author today.
I know. Famous. That's not an adjective that people use in describing me. Infamous, maybe, but not famous. But yeah, I do a lot of estate planning. But I also have. We've got a private letter ruling request in front of the IRS right now. We've got a large estate tax return that we are fighting with the IRS over right now. I've done all kinds of private letter rulings. I've been to Washington to argue a case with the IRS, which was actually very funny. I know this has nothing to do with what the topic was, but
It's very interesting.
they told us, what you do is you submit a very detailed ruling request from the national office to find out how they would rule on a hypothetical thing before you do something and end up getting slapped with a bunch of taxes. So we'd submitted this ruling request, and the initial response that we got back was, we're going to rule against you. well, you can ask for a conference. And so we said we'd like the conference. So we went there, me and one of my partners. And we walked into this meeting, and there were about 4 or 5 agents there, which is always kind of intimidating. The IRS office, you know, it's got these marble walls. It's like you're walking. I think they're trying to intimidate you. Anyway, so we walked in there and walked into this office, and there were all these guys there. And after about 5-10 seconds, this other guy walks in and sits down, doesn't introduce himself or anything. And so we make our pitch, and it does not sound good. And so we were walking out, and Len, my partner, Len and I are walking down the hall saying, oh, that didn't sound very good. That didn't sound very good. So this guy who walked in late comes running down the hall after us. And he said, hey, can I ask a question? We said, well, sure. And he said, do you think this is going to promote President Bush's education program? And I looked at Len, and Len looked at me, and then we looked at the guy and said, absolutely. Had nothing to do with the education program. But we got our ruling. So, politics is a very funny thing. So, anyway, that was my big chance to argue with the IRS. Anyway, that's not what I'm here to talk about.
So, but no, that was interesting, and I would say probably most of us haven't been to the IRS office in Washington.
No.
So,
No.
I hope that we never do. So, all right, so the big, beautiful
I hate
Bill
that
Act,
name.
he's
I hate
changing it,
that
right?
name. Oh, just call it a tax bill.
Okay,
Just,
so give us, the highlights of it, specifically, about seniors. And I will tell you, I know you can't see all this slide. This is one of your actual handouts. So it's the last page in there.
Actually, I can't read that, so I'm going
Okay.
to pull out my copy. So and I don't know where you guys are politically. I hate politicians. I think that they are lying to us most of the time. And all of these things like the big beautiful bill, that it's just propaganda, and it drives me nuts. I just let's solve the problems and stop with all of this runaround stuff. Anyway, with that, so this was signed into law on July 4th. Isn't that sweet?
Yes, so ironic.
No, he was pushing. He was pushing for it to be signed on that date.
Oh, I know, yeah.
Oh, it was
Yeah,
all
no, that was
political.
very purposeful, yes.
And
Mhm.
it's major tax reform and Medicaid reform, and there are a few provisions that will have an impact on seniors. It says in the notes here, it says nicknames that one big beautiful bill. And I guess we're going to have to refer to it from now on like by that name, which is really bad. The big thing for seniors is there is a $6,000 deduction that you will get. Each of you, husband and wife, both get it. And so there's a $6,000 deduction that you can take. And you can take it even if you're not an itemizer. So you don't have to do the itemization schedule, so you can just take it. Now they think what's going to happen, you can get 100% of that deduction if you're single, if your income is up to $150,000. When you get over that, there's a reduction, and then you lose it completely at $175,000. With a married couple, it's $150,000 that you can take the entire deductions, because in that situation it'd be $12,000. But over $250,000 you get nothing. And so you want to be poor. You want to be.
Well, you want to be under 250.
Yeah, you want to hide your money. The Cayman Islands. It's a great. No, I'm not. It's a joke. It's a joke.
So it's a phase out.
Is anybody listening? I don't know.
No recordings.
Anyway, so it's effective from 2025 to 2028. It phases out at higher incomes.
Sorry. And you have to be 65 or older.
I'm sorry.
Yes.
Yes, 65. You have to be 65 to take advantage of it. They are projecting that right now and the numbers, I didn't find any exact numbers, but they say that like 50% of seniors don't pay any taxes on their Social Security, somewhere in that number. I don't know where the range is actually. They're saying that with this deduction, that it'll knock only 10% of the seniors will be paying taxes on their Social Security. So this is going to be a tremendous advantage for seniors to be able to eliminate or reduce their taxes. So it is a benefit, a real benefit.
Yeah, we'll take
for
it,
seniors.
right? Yeah.
Well, if you have to,
If you must, yes.
I'm always amazed, those multimillionaires that say, oh yeah, we should be paying taxes and stuff. My question is, why don't they just contribute their money to the government? And I don't want to be taxed anymore. If you want to pay taxes, just give it to them. Okay, on the estate planning side, the exemption, now I know that all of you, that this will be a concern for you, but the exemption amount this year is $13.99 million. And I know that if you're not there, I know you're real close. That was supposed to sunset this year because when they passed the bill, first of all, they have to meet certain economic, standards, or at least they claim that they're meeting them. And so they had to sunset the bill when they first passed it during Trump's first administration. Well, what they did was they made it permanent this year with this bill. And so the exemption amount is still $13.99 million this year. It's increased for inflation. Next year it goes up to $15 million. So you can make an extra $1 million this year and you won't have to worry about estate tax. And if you're making gifts, I think this is an older audience, I hope no one is offended by that. Anyway, if you're making gifts, people they're concerned about, well, if I make a gift to my children or my grandchildren, am I going to have to pay taxes on it? Well, we have what's called a unified estate and gift tax system. And so if you're not anywhere near the $13.99 million, don't even bother filing a Form 709, the gift tax return, because the penalty for failing to file the return is a percentage of the taxes that you would owe, and if you're under the $13.9 million, there's no pay. It's one of those interesting things in the regulations that's there. It doesn't necessarily make sense, but so don't even worry. If you want to make gifts to your kids or grandchildren, that's fine. Don't worry about that. I did want to, and there's a note here about great time to review estate planning strategies. I always tell people that you should review your estate planning strategy maybe every 5 to 7 years. Some attorneys say you should do it annually, but oh my gosh, it's so dull and boring. Have you ever read these things? Anyway, so I'm not sure that you really want to review it that often, but when you review your estate plan is first when you win Mega Millions. Isn't that one of those? I don't play the lottery. Is that one of those lottery things, Mega Millions?
I don't play it either, but
Yeah.
it sounds right.
Sounds good. Sounds good. So, if you come into a bunch of money, an inheritance or something, or, literally, if you do, I keep waiting for the lottery winner to walk into my office. I haven't had that yet. But anyway, so if there's a change in your circumstances, not necessarily a child getting married, a daughter getting married and changing her name, you can track that through. That's not a problem. If the person that you named as trustee has gone off the rails, they stopped taking their medication, literally that happened, and the woman that was named, she developed a probably inappropriate attraction to Uber drivers. So that's true. Anyway, so my client said maybe it's time for a change. I thought that made sense.
Agree, yeah.
Yeah. You don't want to be too rash in your thought, but anyway, so if there's a change in the people, or I have people that come in and their estate plans are 20, 30 years old. Do you think I need to change this? No, don't worry, the laws haven't changed at all. No, they have changed. And so if you have an older estate plan, yes, look at it, maybe talk to an attorney about it. But I don't think you need to do it every year. I know that there's some attorneys out there that do that. Getting back to gifts to children and grandchildren, some people do 529 plans, the education IRAs. One of the things that this law did is that it expanded the qualified purchases, is a term that's used, the qualified distributions that you could make. I think that it used to be you could use the money for tuition and room and board. Well, they've expanded that. I had to print this out so I could have a list. Educational materials such as books, workbooks, curriculum, online educational materials, tutoring, testing fees, dual enrollment, fees for college level courses taken while in high school, therapies, educational therapies. I'm not sure what that is. Maybe you guys are, into education and anyway, and homeschooling. And so you can actually use 529 plans now for more purposes than what they used to be. So those are very useful.
So yeah, we used to just kind of be straight tuition.
Tuition, I think room and board.
Room and board, okay.
I think you could use it for that. Now, there are some cuts in the law. This is my commentary. I'm just very concerned about, the deficit that we've got, and I don't know how this can keep on going, and it makes me nervous. There were some cuts in some programs. Are they fair? I don't know. But it just seems to me that something needs to be done. Medicaid funding is reduced. I don't know that any of you are on Medicaid, but you might have children that are, or relatives. The SNAP benefits are cut. There are new paperwork. This is the government, so they like paperwork. Have you guys ever read the fascinating? No, they're dull as dirt. Anyway, the subsidies for the Affordable Care Act insurance that's out there, most of you probably are on Medicare, and so maybe you don't have the Affordable Care Act coverage, but if you have family that does, they're cutting back on the funding of that. That's part of the way that they're going to be saving money. And the CBOs, the Congressional Budget Office, they're projecting that there will be millions that could lose coverage. The question is, well, what do we do for these people? And so it's a very difficult situation. You're furrowing your brow.
There's some downsides. There's some, like,
Right.
you're going over the cuts that were in the bill that cuts funding. And I don't know if it affects anybody here in our audience today, but I'm sure we all know people
Right.
that this may affect.
Right, and it's a difficult position to be in for sure. And so recommendations as far as what you guys should do, take advantage of that new $6,000 senior deduction if you can, unless you're making millions, and then come see me. And then, this is a no-sell, so that's right.
Yeah.
I'm not supposed to say things like that. Anyway, revisit your estate plans periodically. Like I said, do you need to do it right here, right now? If you had it done last year, the year before, probably not. The last major change in the law was for Missouri was in 2011 when they created the qualified spousal trusts, which made joint trust between a husband and wife tenancy by the entireties, which gave you some asset protection features in the law. So there really hasn't been anything, to my recollection. There's nothing that's been major that affects most people. But like I said, get out your plan every 5 to 7 years and dust it off. Look at your costs for health care, food, for all of your necessities that you have. And then when you're doing your review, so I write these columns. Next week, I just wrote the one for this next week that'll come out, and it's about selling your business. And I have a few minutes so I can talk about this. This really sweet couple, they had a food service business. They had a customer they thought they could trust. They sold their business to the customer, and the customer failed to pay like 25% of the purchase price and just walked away. And it was quite a bit of money. And so I felt so sorry for him. But if you're going to, they say that in the next 20, 30 years that there's going to be this huge transfer of wealth down to the younger generations, whether it's businesses or assets that you've collected. But if you're selling a business, just be very careful. So that's what the next column is going to be. And then I already have the idea for the other one. Of course, my brain went on a fart.
Well, I had, while you're trying to think of that, I had two things. ABLE accounts, wasn't that something that was expanded? You're able to put more money into ABLE accounts?
Right, there are, yes, yeah, a simple answer is, so what they did was and maybe this is an intelligent thing that they're doing, which would surprise me, but maybe what they're doing is they're encouraging seniors to stash more money away out of concern about what might happen to Social Security. Now, there was a lot of discussion about making Social Security tax exempt, and that did not get in the final law. So your Social Security still is subject to income tax, but they have created some, additional opportunities out there for you. And I would suggest, I don't do income tax returns. I hate them. Do you like income tax returns? Yeah, I hate them. I hate preparing them. And I'd much rather do an estate tax return than an income tax return. Anyway, so talk to your income tax person, and they'll be able to kind of walk you through all of that. Was there a hand that went up? Yes?
I thought in Missouri, we didn't need to pay tax on Social Security. I thought that changed like maybe last year.
That's Missouri tax, not federal.
Okay.
We have two different tax. Isn't it nice? You've got Missouri taxing you, and you've got the federal government taxing you. Anybody else out there that could, they would tax you. The state, the county taxes you. So anyway, the library district taxes you.
Do, yeah, that's part of it, right?
But we appreciate their meeting space, so yeah.
I think you mentioned that as the giver, we don't have to pay taxes on gifts.
No.
To our children. To our children.
Well, wait. If you have an estate over the 1399, okay, you're just so close, yeah. No, you don't have to pay, if you're under that exemption amount, you don't have to pay taxes on it. No, they don't, but maybe what you want to tell them is, I'm going to give this to you, but you need to pay back. Just a thought, no, nobody, it's a gift tax, so that in Missouri, now other states, I want to say Indiana has got an inheritance tax, so that the people paying the tax are the people receiving the money. In the federal regimen, it's the estate that pays the tax, so that it's a net amount that ends up going to the heirs. And that's the same way with gift taxes, that it's the donor that has to pay the tax.
What is the ABLE accounts that you were talking about? What does that mean?
ABLE accounts.
What does it stand for even?
I don't know exactly what it stands for, but it's for like disabilities and that, right? Like it would be to, like, if you have a child or a grandchild that you want to put money into it's an ABLE account that you can put it in. So it's a special needs type situation.
If you have a child that is receiving government benefits for Medicaid or SSDI or whatever you might be.
It doesn't go against them.
You want to make
sure they won't lose their benefits, but you can still contribute to an ABLE account.
Yeah, which it's a special needs trust.
And I mean, it's something that, again, if that's not, you have that in your family, you're not aware or don't know about it. But if it is in your family, it's a big deal. If you have a family member that is going to need life care, that you want to be able to give money to
without messing up their government benefits.
Right. Yeah, exactly. It's a big deal.
Is an ABLE account like a special needs?
Right. That was what we were saying. Was it's a special needs kind of an account.
I do have a daughter who receives Medicaid. So what is being reduced? She is totally disabled.
So I think it allows you to contribute more money you can contribute more money to able accounts. I don't know you're going to need to research it, so I'm sorry, we don't have all the details on it, but that was one of the, I think, the things that's more liberal now, is contributing to able accounts, and that, it will not impact your loved one's benefits of disability or Medicaid.
Right.
So ask your tax person and specifically about that. Yeah.
Any other questions?
Yes, ma'am.
On the subject of gifts, if you foresee that, like I do personally, foresee my husband's going to have to go on Medicaid because he's been in a nursing home, that's something you can't play with then. Can you give him gifts? Because if the Medicaid, the government sees that, you got rid of things,
You're talking about like the 5-year look back?
Yes.
Well, two things. One, if a spouse goes into a nursing facility, you need to do a division of assets so that you have your half of the assets and then he has his. He spends them down, and you can make gifts out of your division, your share of the assets. But if there's anything that he gives, or if before you do the division of assets, if you make a gift, there is a 5-year look back, and they add it back in. And I've run the numbers, and the numbers are almost punitive. The way that it works, it's almost like they're going to charge you or treat you as giving more. Let's say that you gave a $10,000 gift to somebody. In effect, the numbers that I saw, it's almost like they're treating you as if you made a $15,000 gift. And so they're really kind of punitive, unless they're using interest rate assumptions that are just ridiculous. But you want to, if a spouse is going into a nursing facility, you want to talk to the social worker there about doing a division of assets so that you can preserve at least. You're treated as the community spouse, and in your case, your husband would be, this sounds horrible, but your husband would be treated as the institutionalized spouse. And so there is a way that you can protect at least half of your assets.
Do you need that with the trust?
Do what?
Do you need a division and you can have a trust?
Yes.
It's something
Yes.
different than,
I was trying to think of a way around it, but I can't.
that is going to be one of our upcoming, yes, it is, division of assets or asset preservation, so, yeah.
Anything else? Okay,
No, okay, all
I
right.
did such a phenomenal job, right?
So look for your articles in the Mid-Rivers Magazine. I would say, the estates and trusts and legal and taxes are all intertwined. So, thank you for sharing your knowledge.
I wanted to, I was told yesterday that, so I published this column in the Mid-Rivers News Magazine and the West News Magazine. And I was told yesterday that I was one of 5 attorneys being considered for the best estate planning attorney. And they're going to have an election, a vote. So I would like to encourage you all.
You're selling now for it.
No, it's not selling. It's not selling, because I just think it would be funny to be voted as the best.
Well, maybe you are.
There are a lot of very good attorneys out there, but if you get a chance to go on and vote, I just think that would be funny. I just think it'd be funny.
So where do you
Sorry.
vote at? So where do you vote at?
Do what?
Where do you vote at?
You have to go online and go to the West News Magazine website. It starts September 3rd, so it's not going on right now. But yeah, the lady that I deal with in submitting my columns, she called me specifically because we always get a chuckle over the columns whenever I write them. And anyway, she said, "Oh, I wanted to let you know." And I said, "What is it?" So anyway, I'm going out. I'm trying to drum up all the support I can.
Well, for how many years you've been doing this, right?
Yeah,
You ought to be the
years,
best.
Yeah. No, I've been doing that. Honestly, I started practicing law in 1982. You guys can remember that far back. So, I'm always kind of amused. So when you write a trust, and you have IRA benefits flowing through the trust because of the 2014 U.S. Supreme Court case that said that inherited IRAs are not protected from lawsuits. Anyway, so if you flow the money through your trust, you have to have IRS magic language. And they published that in 1999, and I remember that. That's just kind of embarrassing, because I have these young people. Were you even born in 1999?
No.
Yeah, so.
I look at people's driver's licenses and I'm like, what?
I know
That year?
my wife.
Your baby.
My wife went to her new doctor, and she came back. She said, "I think she's out of high school."
All right. Well, thank you, Fred, for being here today. Appreciate it very much, and hope you win that News West magazine. So thank you guys for attending. Don't forget to sign up for our upcoming seminars. Our next month one, let's see here. Working after retirement, what you need to know. This includes volunteering, the impact on your Social Security, and different opportunities that you may want to consider. And then we have October, we're going to have somebody from Missouri SHIP. And then it's open enrollment time. And November, we're going to be talking about asset preservation, which was something that you just brought up. Oh, real quick, Missouri raised the capital gains exemption for selling a primary residence.
Right.
Yeah, that's a big deal.
Yeah. So.
That was one of the things, not part of, as a state thing.
Right.
Not a federal thing.
Right.
But yeah, that's a nice thing for us who own property in Missouri. So, all right. Thank you so much, guys.